Nigeria, 1999, as amended, which provides that in the determination of the rights and obligations of a person by or against an authority or government, that person shall be entitled to a fair hearing within a reasonable time. The true purport of the concept of fair hearing is enunciated in, for instance, the case of Mbanefo versus Moloku, citation supplied, where the apex court held inter alia as follows: it cannot be overflogged, the cardinal principle of fair hearing, and a hearing is taken to be fair when all parties to the dispute are given a hearing or an opportunity of a hearing. If one of the parties is refused a hearing or not given an opportunity to be heard, the hearing cannot qualify as fair hearing. End of quote. Fair hearing must be a hearing that does not contravene the principles of natural justice. It is therefore trite that any judicial, administrative, or quasi-judicial body exercising any functions in any proceedings where the rights or obligations of a person is decided in contravention of the principles of fair hearing, such shall be rendered null and void. It is important to note that the question whether a person was afforded a fair hearing is dependent on the facts and circumstances of a particular case. So the question is, was the claimant afforded a fair hearing before he was dismissed from his employment by the first defendant? A review of the facts, which are corroborated by sufficient evidence before me, revealed that the claimant was served with a letter, Exhibit C7, by the second defendant, wherein he was requested to explain the whereabouts of the check drawn up by the first defendant in favor of the second defendant. The claimant tendered Exhibit C8, which is his response to the second defendant's request in Exhibit C7. It is also factually established by evidence in Exhibit D5 that the second defendant wrote and informed the first defendant about the supposed withdrawal of the sum of 464,000 naira by him from a Keystone Bank account wherein he had deposited the money and subsequently withdrew same for either unknown or for his personal use. There's also Exhibit D6 titled Official Report of Illegal Diversion of 464,000 naira Union Levy. I read paragraph 4 of the said Exhibit D6, which is worthy of reproduction hereunder, and I quote: "We want to inform your office that Comrade Prince Dimpa illegally diverted and converted National Union levy money to his personal use. On that note, the National Union view it and summarize it as nothing but a fraud. Therefore, he is not fit to work in a reputable organization like PZ Cousins Nigerian PLC." End of quote. It was on the basis of these correspondences from the second defendant that the first defendant served Exhibit C9, titled Dismissal, on the claimant. Meanwhile, DW1 testified under cross-examination that the first defendant cannot issue another query after the one already issued. DW1 alluded to the first defendant acting through the second defendant. Meanwhile, for the clarity of emphasis, I shall reproduce the salient excerpt from Exhibit C9 as follows. In accordance with your terms and conditions of service with the company, we confirm cessation of your employment by dismissal with effect from the 18th of September 2018. This decision had been taken as a result of the company finding you culpable of illegally diverting the union levy for personal use. This act is unacceptable and contrary to standard company's practice. End of quote. Again, Can it be said that the first defendant afforded the claimant fair hearing before dismissing him? In the face of these evidence before this court, it is only reasonable to answer this question in the negative. Hence, the answer is a palpable no. There is no doubt about the legal persona of these defendants, but it may be necessary to emphasize that the first defendant is a public limited liability company incorporated under the Companies and Allied Matters Act, whereas the second defendant is a trade union registered under the Trade Unions Act, Cap T14 LFN 2004, for employees of the category of the claimant. There is no gainsaying that these defendants are not one, but two distinct independent legal entities. I should also add that the claimant is an employee of only one of them, that is the first defendant, but a union member of the other, that is the second defendant. Put simply, the first defendant is the employer of the claimant, but not the second defendant. As such, the claimant's letter of probationary employment, Exhibit C1, for example, clearly illustrates who the employer is, and this is certainly not the second defendant. Besides, all other evidence supplied in this suit by both parties clearly suggests that these defendants understand that the first defendant is the employer of the claimant, who ultimately has the power to hire and to fire the claimant. This supposedly explains why the first claimant directly issued the letter of dismissal, that is Exhibit C9, which is also Exhibit D10 to the claimant, and not with the authorization or approval of the second defendant. In my mind, these set of facts are settled and need no further elucidation. Incidentally, the defendants tendered Exhibit D6, which is the second defendant's official report to the first defendant on the alleged actions of the claimant. The last paragraph of the said report reads as follows, and I quote, "Attached is the query and reply issued to Comrade Dinkpa. Also, Keystone Bank statement of account for your personal perusal, end of quote." Apparently, the first defendant, after perusing the said attachments in Exhibit D6, took a swift decision to summarily dismiss the claimant's employment without ado. Whereas I find it difficult to come to terms with their line of defense pursued by these defendants, and by this I mean the defense that the query and reply letters between the claimants and the second defendant suffice to justify the dismissal of the claimant by the first defendant, it must be emphasized without mincing words that the report by the second defendant to the first defendant, including the documents said to have been attached therewith, are merely allegations made against the claimant and nothing more. It is needless to point out that the second defendant is not a court, an arbiter, or a commission set up to inquire the allegation, or even a tribunal whose verdicts, award, or report the first defendant can safely act upon. The second defendant, at best, is an employee's representative, which ordinarily should be seen to be acting in the best interest of its members, including the claimant. It is, however, clear from Exhibit C9 or D10, the letter of dismissal, that the first defendant acted solely on the report or finding made by the second defendant in dismissing these claimants. How can it be said that the first defendant gave the claimant an opportunity to be heard before dismissing him from its employment? I think the first defendant swallowed hook, line, and sinker what the second defendant fed it without even chewing it. And this, indeed, is fatal blunder on the part of the first defendant. Although I concur with the learned defendants' counsel that Article 6D of the Junior Staff handbook excludes allegations of gross misconduct from other matters requiring informal warnings, formal letters of warning, or final warnings as provided therein. I, however, need to draw the attention of learned counsel to the provisions of the preceding Article 6A, which provides that the disciplinary code is necessary both for the success of the company and the fair treatment of individual employees. Fair treatment, as used in the said regulation, I believe, connotes giving an employee a chance to defend himself from any allegation before taking grievous actions like a dismissal against him, as nothing short of this can suffice as a genuine fairness. Excuse me. This, of course, is also in keeping with industrial and employment best practices, which this court can suo motu recognize and uphold for the purpose of giving a fair judgment. It should be understood that there is a paradigm shift in the law on dismissal and termination, since it is now required that employers must justify every termination or dismissal. It is no longer fashionable for an employer to terminate for good or bad or for no reasons whatsoever. This court is empowered by its new legislation to modify the traditional common law doctrines, which hitherto gave employers unfettered discretions to perpetuate unfair terminations and dismissals. It is in cognizance with international best practices and our constitutional laws to allow an employee the opportunity to be heard before his employment is outrightly dismissed, even if he committed an act of gross misconduct. Above all, fair hearing, again, is an organic law of nature, and the right to fair hearing is a constitutional one. Assuming that the said handbook, Exhibit D9, even expressly denies an employee's right to fair hearing on matters of gross misconduct, such provision would automatically be declared null and void, since it is clearly inconsistent with the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Section 1.3 of the CFRN 1999 is apposite. Borrowing the obiter of the appellate court in Ogboru versus President Court of Appeal and others, and another citation provided, the court is a creation of the Constitution. It will not give its aid to a violation of a provision of the Constitution which gave it life. Such travesty of justice as found in the instant case where the first defendant perfunctorily dismissed the claimant with utter disregard excuse me, to his right to fair hearing must be deprecated. In effect, the dismissal of the claimant by the first defendant in this suit was unfair and wrongful, and I so declare. I wish here to state quickly, though, that I absolutely do not believe the claimant's claim that the check for 464,000 naira issued by the first defendant in favor of the second defendant union was a personal loan from the national president of the second defendant's national body. This was indeed a deliberate mistruth and an afterthought. Exhibit D1 is a copy of the said check, and I have taken a cursory look at it and do not find the name of the said national president of the second defendant on its face. I completely agree with the submission by learned counsel for the defendants that the burden of proving that the check was a personal loan is on the claimant. More so, all through the trial of this suit, the claimant did not call in the evidence of the said national president of the second defendant's national body in order to establish this claim. I am also inclined to agree that such material evidence withheld by the claimant could have, if produced, been unfavorable to him. Section 167D of the Evidence Act 2011. Meanwhile, the nature of the or type of employment in this suit is not in contest whatsoever. Hence, it is safe assumption that both parties appreciate was in a master and servant employment, and not a statutory one. It is tried that in the case of wrongful termination of employment, the claimant shall be entitled to legitimate entitlement due to him at the time of the employment, at the time the employment was brought to an end. You may see Nigerian Product Markets Board versus Adewumi, citation supplied. This point was clearly re-emphasized by the Apex Court in Patrick Zide versus Rivers State Civil Service Commission, citation supplied. At this juncture, it's imperative to take a second look at the claimant's reliefs in this suit. By his second amended statement of facts, these are the claimant's reliefs once more. 1, a declaration that the purported dismissal of the claimant by the first defendant through its letter dated 18 September 2018 without hearing the claimant is illegal, unlawful, null, and void. 2, a declaration that the claimant is still in the employment of the first defendant. Or in the alternative, an order directing the first defendant to pay the claimant his full salary allowances for the 10 years unexpired period of his employment till his retirement after 30 years of service or 60 years of age. That is to say, the list is made about 13, which add up to 67,199,473 naira 96 kobo. And thirdly, 15% interest on the judgment sum from date of judgment until judgment is liquidated. This court already declared that the claimant's dismissal by the first defendant was wrongful and unfair, in that the claimant was not afforded a fair hearing before he was dismissed for an alleged misconduct. In essence, the claimant's relief number 1 is partially granted. Against the backdrop of the foregone judicial authorities, it is only natural that the claimant's relief number 2 cannot be granted, given that the employment is purely a master servant one. I shall not foist an employee on an unwilling employer, given the facts and circumstances of this case. Reinstatement is therefore not a course available to this claimant, even considering this court's earlier decision in Bello Ibrahim versus EcoBank PLC, Par Kado J, in suit number NICN/ABJ/144/2018, or the Court of Appeals decision in Sahara Energy Resources Limited versus Oyebola, which were not even cited and relied upon by the claimant's counsel. It is bound to fail, and same is hereby refused. The alternative relief number 2 is for salary allowances for unexpired 10 years. It is a relief for anticipatory claims in the form of salaries and allowances the claimant would receive for 10 years until his retirement, but for the unfair or wrongful dismissal of his employment. Paragraph 17 of the claimant's second amended statement of facts states inter alia, and I quote, "The claimant shall show that he was not paid salary after his dismissal, was not paid any gratuity, and was not duly paid his SPF contributions," end of quote. From the above stated alternative relief of the claimant, which he also reproduced in paragraph 16 of his second amended statement of facts, it is deducible that the claimant seeks for entitlements for the unexpired 10 years purportedly remaining of his service in the first defendant company. Thus, the total sum of 67 million naira sought for in the alternative relief is not the sum the claimant was owed or entitled to at the point of his dismissal, but the sum he would receive as salary and other allowances and entitlements from 2018 until retirement 10 years later, were he not dismissed. The claimant is quite ambitious. Even though this court held that his dismissal was unfair and wrongful, the action itself was not held to be illegal, null, and void. That is why the claimant can only be entitled to damages by way of his unpaid entitlements due to him as at the date of his unfair or wrongful dismissal only. You may see Patrick Zide versus River State Civil Service Commission, SUPRA. Where a servant's employment is wrongfully terminated, he is only entitled to be paid all outstanding monies owed him, including any salary in lieu of the required notice before such wrongful termination. It is irrelevant if the claimant pleaded for it or not. You may see the recent decision in Toyimbo versus Union Bank PLC, 2023, 1 Nigerian Weekly Law Report, Part 1865-403. The damages awardable to the claimant should not exceed his salary and perquisites of office, as at the time notice was not given to him of his termination. It follows, therefore, that the claimant's projected 10 years entitlements from 2018 until retirement is asymptotic of an imagination stretched way too far. Accordingly, the alternative relief is hereby refused. Furthermore, the claimant stated in paragraph 9 of his reply to the statement of defense filed on the 12th of March 2019, that after he was paid the sum of 1,343,200 naira, 10 kobo, by the first defendant, he was owed an outstanding balance of his pension contributions in the sum of 2,014,800 naira, 15 kobo. Exhibit C17 is a PZ SPF detailed statement of account from Stanbic IBTC for the periods from 1st July 2016 to 30th September 2016. On the face of the document, there is a statement summary detail section which shows the following. 1, contribution from inception, which is 1.4 million. Total withdrawal, nil. 3, net contributions to date, 1.4 million. 4, gain, loss from inception, 1,096,000. And 5, current value, 2,554,353 naira 95 kobo. The defendant tendered Exhibit D10, which is a copy of the check issued by the first defendant in favor of the claimant in the sum of 879,000 naira, 10 kobo. The first defendant had asserted or had assessed the claimant's pension entitlements to be in the sum of 1,343,200 naira and 10 kobo, but deducted the sum of 464,000 naira from it as the value of the amount in the check allegedly diverted by the claimant, thus bringing the balance to 879,000 naira, 10 kobo, payable to the claimant. I am constrained to lay bare the fact that in determining the balance of the otherwise of the pension sum due to the claimant in this suit, a relevant PZ SPF detailed statement of account from Stanbic IBTC is a sine qua non. The one tendered by this claimant as Exhibit C17 is only for the period from 1/7/2016 to 30/9/2016, whereas he was dismissed on the 18th of September 2018. The court cannot fill in the lacuna created, since it is not the business of this court to speculate about missing facts. Rather, the onus is still on the person who asserts to prove his assertion by credible evidence. In all, the claimant's suit fails, but for the declaration made above about the unfairness and wrongfulness of his dismissal. I shall not award any damages to the claimant regardless of that. Judgment is accordingly entered. Parties shall bear their respective costs.
As God pleases.
Are they still online?
Lord,
Yes, my Lord. As God
Lord,
pleases, my Lord.
my Lord, as God pleases, and we must appreciate my Lord's judgment. That's a erudite judgment that is well delivered. Thank you, my Lord.
All right.
Quite expository and revealing.
Judgment.
We will get, yes. Who is there? Who is there?
David Onike.
Okay, yes. You'll get a
Can you hear
copy.
me, my Lord?
Yes, I can hear you.
I say I thank my Lord for the judgment delivered and the space at which it was the promptitude and the pace which you take to deliver it. So welcome, my Lord. Thank you, my Lord.
I wish you all the best. You'll get a copy of the judgment immediately after proceedings today.
As God please, my Lord, we also thank my Lord so immensely for the judgment well delivered. Thank you, my Lord, for the erudite judgment. Like I said, it's expository and revealing. And we appreciate my Lord for his integrity.
I thank you too. Will there be any more applications?
None, my Lord. We
All
are,
right.
we are grateful that my Lord is going to make the judgment available to us.
Immediately, and you'll get certified copies of them from the registry.
As God please.
Immediately. Thank you. In the absence of any application, registrar, any application?
My Lord?
Any?
No, my Lord.
Okay, no announcements, no applications.
Yes.
Yes, my
All
Lord.
right. The absence of any, I shall take my leave. The court shall rise.